Whether it's the killing of Qassem Soleimani in Iraq or targeted drone strikes, today we'll be taking a look at the controversial legal argument that the government has for targeted killings. Hello and welcome to TalksOnLaw. I'm Joel Cohen. Our guest today is Judge Andrew Napolitano, senior judicial analyst at Fox News and a visiting professor at Hofstra Law School, where you teach on constitutional issues.
Yes.
Judge, welcome.
Thank you. It was a pleasure to be with you, Joel.
Today we're going to be talking about targeted killings. It doesn't seem like something that fits with our general notion of due process, going out, finding someone, killing them.
Well, that's putting it mildly. I mean, the most controversial of these, and the one that piqued the interest of the media, was the murder of Anwar al-Awlaki in the Obama administration.
U.S. citizen.
Correct. Mr. al-Awlaki was born in New Mexico. Along with al-Awlaki was his 16-year-old son, also born in the United States, and the son's young friend, also 16 years old, but not an American citizen. It was controversial because there was no crime charged. I mean, he may have committed crimes, but he wasn't indicted. No criminal charges had been filed against him. And that provoked demands by the media for the legal justifications or justification used by the Obama administration.
These are the justifications that were also used by the Bush administration prior and are currently being used by the Trump administration.
Well, it was written by Eric Holder, so I doubt that it was used by the Bush administration. The same theory might have been used, but not the same document. I've never seen any document generated by any legal apparatus, whether it's the Department of Justice or the legal team in the Department of Defense from the Bush administration.
Perhaps first, let's start with the justifications. It starts from a different type of power. It doesn't start from this criminal justice type of a route. It comes from what's sometimes called the war powers.
Yes, and this is the justification the government used. So the government's argument is this. I'll make it in as pro-government a way as I can. Look, this is the most efficient means we have of keeping the country safe. It targets an individual. It doesn't kill innocent people, for the most part, depending upon how refined the weapon is and who's in the area. It doesn't destroy property. And because it's not always done by the military, it doesn't even require a declaration of war by the government and isn't even reportable under the War Powers Resolution. So it is basically the use of the minimal force needed to rid the country of its enemies. So the American public should be happy that the government is using minimal force rather than maximum force. That is, I think, a fair summary of the arguments made by the Bush administration and the Obama administration, and somewhat by the Trump administration.
How about the constitutional argument that the president has the power as commander-in-chief to defend?
Well, the constitutional argument's a dangerous one, and they have not made this because the Congress declares war and not the president. If you want to make this the president's war-waging power, because he theoretically doesn't have war-making power, if you want to make it his war-waging power, that implicates the War Powers Resolution, implicates reporting to the Congress. Now, the Trump administration has not made their legal arguments known publicly because they don't want to reveal what the basis of their authority is, because they want to avoid the war-making power of the Congress, since one of the houses of the Congress is controlled by the other party, the Democrats, and they don't report this under the War Powers Resolution. Barack Obama avoided the War Powers Resolution reporting requirements, which expressly says military, by using the intelligence assets to locate, identify, and even pull the trigger. That's a real technical, in my view,
well, he was a constitutional scholar.
Correct. Escape from the War Powers Resolution, but it was probably a legal one.
Why don't we start with a concrete example so that we can look at these more complex doctrines. In 2019, the Trump administration, President Trump himself authorized the killing of Qassem Soleimani. There, what was the justification? Was it this war powers argument?
All right. General Soleimani was a very high-ranking official in the Iran government who held roles comparable to, in the American system, both the chairman of the Joint Chiefs of Staff and the director of national intelligence. He was the rough equivalent of a 3- or 4-star general, but he also ran the intelligence apparatus of the Iranian government.
Wildly powerful person within the country.
Extremely so. The argument made by the president when he announced this and then justified it and then in Trumpian fashion boasted about it was that the general was in Iraq planning to attack 4 American embassies. He was unable to name the embassies. When Secretary of State Pompeo was asked about this, he said, I don't know anything about any embassies. And when
he was attacking 4 embassies across the Middle East?
American embassies, the president didn't say where.
Okay.
Where the president got this 4 embassies from, nobody can say. Somebody, I think, said to him, you're going to have to make some sort of an imminent argument that his behavior was harmful and the harm was imminent in order to fit within the justification for pulling the trigger first.
Right. So in that case, Soleimani, who wasn't this Iranian military official, what justification did they use? They said there was going to be the attack on these embassies, and they used the 2002 AUMF to justify it?
So there's 2 AUMFs. AUMF is authorization for use of military force. The 2001 AUMF is for the invasion of Iraq. The is for the invasion of Afghanistan. The 2002 AUMF is for the invasion of Iraq. The stated purpose of the 2002 AUMF is to rid Iraq of what we now know it never had, which is weapons of mass destruction. The underlying purpose, of course, was to rid Iraq of Saddam Hussein. The government certainly succeeded in that respect. Both of those AUMFs are still extant, even though Afghanistan theoretically poses no danger to the United States now. We've been there for 18 years. And even though Iraq theoretically poses no danger to the United States, and even though the purpose of the AUMF was fanciful and incapable of being achieved, but the government dusted that off and used it. This, of course, raised a lot of eyebrows in Congress. Why is this thing still around? It's like a loaded gun on the president's desk for him to take out and pull the trigger whenever he wants.
The 2002 AUMF was limited to Iraq.
Was limited to Iraq by the plain language that's in it, which is why they claim they waited for him to get to Iraq. If they had killed him when he was in Iran, it would have been an act of war. Still an act of war because it was done without the knowledge or consent of the government of Iraq.
And the government of Iran described it as an act of war.
It was an act of war by almost any fair measurement of what an act of war is. When did we start killing officials of governments with which we are not at war? Never.
And in fact,
Till now.
Since Ronald Reagan, there's been a presidential memo in place saying that we don't engage in what are called political assassinations.
Yes. That actually goes back to Gerald Ford, and every president but the present one, Trump, has renewed it. Now, in theory, Trump is not bound by it. No president is bound by an executive order of a predecessor. But the proper way to address that is to rescind it. Trump has not done that. He's just disobeyed it. He doesn't feel bound by it, and legally he's not bound by it.
In the president's justification for the Soleimani case, they also mentioned the president's Article 2 powers. Is that just generally the power to lead the military?
So this is requires a little bit of history. Madison wrote that the president is commander-in-chief only in actual time of war, meaning leading the troops. His vision was George Washington on a white horse. The modern interpretation of the president as commander-in-chief is the sort of absolute ruler over the military who can send them wherever he wants to send them. George W. Bush argued that he had powers as President of the United States from some source other than the Constitution. Now, he could never identify that source. However, the people around him said it came from the concept of nationhood. Heads of nations always have power to do things to defend the nations, whether it's reduced to writing in the founding document or not. I think that's the fairest way for me to describe what the Bush argument was. When the Trump people said Article 2, they are talking about that initial language that I talked about, Commander-in-Chief. And the Commander-in-Chief's duty as Commander-in-Chief, as Trump articulated his job, his understanding of his job, is to defend the nation by pulling the trigger before it's pulled on us. That's, again, the reason for he was planning to attack 4 embassies, for which no evidence has ever been produced, in public or private.
That justification, they list the AUMF, they list the Article 2 powers. Are they both necessary? Are they saying we can do this type of killing because it's in Iraq, because it's under AUMF 2002? Could they do the same type of thing in another country?
Well, it would depend on what that country is. If the country is a member of the United Nations, then they can't kill anybody without the consent of the Security Council of the United Nations. That's pursuant to a treaty, unless they're going to violate the treaty. The rules of war require proportionality. You can't use an atomic bomb to kill a mouse, as a simple but silly example. And they require that before you pull the trigger, the person you're aiming at must be certainly about to attack you. Certainty is the requirement.
Is the government's justification limited in any way by the fact that he was an official of a member nation of the United Nations?
Yes. I mean, arguably, this violated the United Nations treaty because Iran is clearly in the United Nations. That has not been addressed publicly. Look, the debate on this died when coronavirus came along. It's a very, very material and profound debate, and I'm happy we are discussing it.
Maybe we can move to another example that we alluded to, which is a targeted killing involving an American. How does that shift the legal scales?
So there's 2 ways to look at this. One is, does the Due Process Clause of the Fifth Amendment, the government cannot take life, liberty, or property without due process, apply only to Americans? It doesn't. It applies wherever the government wants to go. It can be trumped, lowercase t, if the Congress declares war. The Congress declares war, that trumps the Fifth Amendment. You can destroy life, liberty, and property of the soldiers and agents of the country or entity against which you've declared war. But if there is no declaration of war, it is clear that the Fifth Amendment applies because it goes wherever the government goes. We know that from the Guantanamo Bay cases. And it requires due process before you can take a life. And no due process happened with Anwar al-Awlaki, the American, or General Soleimani, the Iranian.
When you're talking about war powers, when you're talking about killing on a battlefield, there's no due process. There's not even the full levels of due process used to discipline your own soldier.
Well, that's because when Congress declares war, that trumps the Fifth Amendment. Neither al-Awlaki nor Soleimani were on a battlefield. Neither was engaged in any act of violence. Neither was armed at the time they were killed. This is not an apt comparison to the use of the war-making power. Neither was in a country at which we were at war.
There's been actual statements that we are in a war against terror. We are in a war against those who are trying to cause us harm.
Well, one of the other arguments that the president made was that, in the Soleimani case, was that General Soleimani had unleashed militias through circuitous routes. He wasn't there. He didn't point the gun. He didn't give them the weapons. But
through funding,
through a variety of high-tech and modern mechanisms, unleashed militias in Iraq that killed American soldiers. I mean, that is a very weak argument. If they felt he had committed murder, because according to the Americans, we are not, to the Trump administration, we're not at war with Iran, even though we're fighting their militia every day in Iraq. If they felt he had committed murder, they could have arrested him. Instead, they killed him. Again, like al-Awlaki, never accused, never indicted, never charged. So it's got to be one or the other. Either we are at war with the country from which he is from, and therefore he is fair game, although you rarely kill generals throughout history. Some of that happened with Japanese generals in World War II. Either we are at war with a country and it's a legal war and their soldiers are fair game, or we are not at war with that country and their soldiers are not fair game. Are we at war with Iraq? No. Are we at war with Iran? No. So how can you kill an Iranian general in Iraq and claim it's justified under the war powers?
How do you have war powers if you're not basing it on a war?
Correct.
So,
Correct.
I think, there is some...
Now, there's war powers and there's war powers. There's war powers, capital W and capital P. That implicates the war powers resolution. There's war powers, lowercase w, lowercase p. That is just a generic phrase for the ability of the country to go
wage
to war.
which
Correct.
is more broad.
In America, because we have a constitution and the separation of powers, we have to decide who's going to take us there, who's going to decide that we're going.
And in the United States, a lot of that power rests with Congress.
Well, theoretically, all of it rests with Congress, but
to declare.
To declare, to
president
decide
will
that we're
still
going to fight war. But the president,
lead the
many
charge.
presidents have done this, probably every president since Richard Nixon. Nixon vetoed the war powers resolution. Even though it's an act and even though it's a law, it's called resolution. I don't know why. Nixon vetoed the war powers resolution because he felt it crimped his style. It interfered with the president's ability to send troops where he wanted
And it
to send them.
required pesky notifications.
Correct. His veto was overridden.
In the al-Awlaki case, it's unique in other ways. There was quite a bit of litigation involved.
Well, al-Awlaki was an embarrassment to the government because in the Bush administration, under Secretary of Defense Donald Rumsfeld, al-Awlaki was brought to the Pentagon to speak to troops and high-ranking military officials about the Islamic mind, to help them understand Islam and its relationship to violence, because even though he was an American, he was an Islamic cleric.
So he was a paid consultant.
Yes, he was paid by the Defense Department. When he went abroad, and in the view of the Bush administration, agitated militias and other groups to attack Americans here in the U.S. and in the Middle East, he put a target on his back. Why do we know he put a target on his back? Because two presidents threatened him. George W. Bush threatened him, and Barack Obama threatened him. In response to those threats, his father brought an action in the United States District Court, and the action is against the president and against the chairman of the Joint Chiefs of Staff. And he basically said, through very competent counsel, these two guys, the president and the chairman of the Joint Chiefs of Staff, are threatening to kill my son. He's out of the country. They're going to kill him. I want this court to enjoin this. The judge dismissed the case. They murdered the son of the plaintiff. The son is Anwar al-Awlaki. Then the litigation was reinstituted seeking damages.
I guess we never had to get into the government's argument before. What was the argument afterwards?
That he was an enemy of the United States, who was an enemy combatant, because he was arousing people to take up arms against the U.S. However, if he was an enemy combatant, the government should have indicted him, which would have justified his being kidnapped and brought to the United States. These people are more valuable as defendants in criminal litigation or civil litigation, as the case may be, than they are in body bags.
Well, Judge, we know how you would have come out. In that case, it was found to be, a political question by the court.
Yes. A political question is a doctrine that federal judges use when they don't want to decide something because they can, with some intellectual honesty, argue this is reposed in the political branches. These are not decisions that judges make. If you have a problem with this, vote him out of office or impeach him. That's theoretically the answer. Don't come to us seeking redress for what the president has done with his commander-in-chief authority.
Why don't we talk about kill lists and, I guess, the legal justifications or questions they raise?
Well, the Constitution, if it could speak, we have judges who speak for it, would find the concept of a kill list abhorrent, because the Constitution only authorizes killing in war, after a declaration of war, or after due process. There's no middle ground.
We know that the due process level, the scrutiny that you would put in, is just not there. But what is the procedure, or is there a due process that's claimed by the government to get on these kill lists?
The Obama administration claimed that it scrutinized the kill list. The scrutiny was never made public. The justification was never made known to us. The names on it were never revealed. As I said, President Obama did order the DOJ or the CIA, whoever it was, to reveal drone strikes that resulted in killing, and to the extent that they could, name the people that were killed. But no legal justification was ever offered.
Let's talk about international law. This, when we justify an act of war or a targeted killing, there's one question justifying it under U.S. law. How are these actions justified in the international law arena?
All right. Well, if the targeted person is physically located in a country that is a signatory to the UN Charter, that would require either an invitation by that country. So not only are they consenting, but they're asking us to come in there and kill this person or these people.
So maybe Yemen saying, we'd like you to do these drone strikes.
Correct. In the case of a non-invitation, it would require the approval of the UN. I know this sounds horrible to a lot of people who believe we should be able to wage our own wars as we see fit, but it's the UN Charter. Not only did we sign it, we wrote it. You can thank Harry Truman and the Senate in 1947 when they ratified the Charter. The Charter is a treaty, and we're bound by it. And under the Constitution, treaties have the same level of respect as the Constitution itself.
Under the UN Charter, there is, in Article 51, the ability for nations to act in self-defense.
Yes.
And is that, that's the argument that's being put forward to justify this type of action.
Okay, but the self-defense contemplated there under the laws of war require imminence. Imminence does not require getting anybody's approval. So if there's a Russian battleship in New York Harbor and it's just about to launch a missile into the middle of Manhattan, the president doesn't have to get anybody's permission to attack that and blow it out of the water because it's imminent. The argument of imminence with respect to al-Awlaki wasn't even made. He wasn't imminently doing anything of which we are aware or of which the government made known. The argument with respect to imminence and General Soleimani was he was about to direct these militias to attack 4 unknown, unnamed embassies of the United States in the Middle East. The secret information given to Congress didn't mention this at all. In fact, 2 senators stormed out of it saying, you're not telling us the truth. This is so profoundly different from what the president has said that we think this briefing you gave us should be made public. It died at that point.
There's a lot of power in the executive here, and we're talking about secret justifications, maybe even secret targets. If there is any oversight, where is it coming from?
There's no oversight to these killings. I mean, there is a statute which creates a Congress within the Congress of 8 people. That's the Speaker of the House and the Minority Leader in the House. That's the Minority and Majority Leader in the Senate. And that's the Chair and the Ranking Member of the 2 Intelligence Committees. And there are statutes that require the government, when it's going to act on intelligence, to share the intelligence with that gang of 8, as it's known, and more or less to secure their approval. There have been many disputes between President Trump and Mrs. Pelosi, for example, as to whether she winked and nodded and approved at certain things, because she's key to the gang of 8. In fact, she's the most important person in the Gang of Eight because she's the only one that is an officer of the United States, Speaker of the House, articulated in the Constitution. The others are just officers of Congress. The question is, can the Gang of Eight acquire all the power of Congress? The answer is no, at least according to Justice Scalia, because the Article 1 begins, all legislative power here invested shall be in a Congress. That power can't be delegated away to some subgroup.
Give a committee.
Correct.
So if that Gang of Eight thought, wow, this is horrendous, we are vehemently opposed to this action, there's really not that much they could do.
That is correct, because the Gang of Eight operates in secrecy, and the unwritten rule amongst the Gang of Eight is they're not going to reveal what the executive branch, either the president or one of his secretaries, state or defense, or intelligence people have told them. Now, can they reveal it? Well, yes, they can go to the floor of the Senate, where it's easier to speak, and reveal it, and nothing can happen. But I doubt that the intelligence community would share with that person anything again if that person revealed what they learned. The exception to this is Senator, in the modern era, Senator Dianne Feinstein, who revealed 6,000 pages of Bush administration torture. She revealed it during the Obama administration. It was secret. She went to the floor of the Senate and put it in the hopper, which made it public, and then she began to describe it. And there's no repercussions. She still receives intelligence briefings.
We do have the example of the War Powers Act, capital war powers, that put some restrictions on the executive power. Is your argument that we need more legislation, more restraints or requirements?
I mean, the War Powers Resolution, which some people call the War Powers Act, both words apply, except that the statute itself calls itself War Powers Resolution. In my view, is wildly unconstitutional for the opposite reason for which President Nixon, a lawyer and a graduate of the same law school as my interrogator tonight,
Duke Law School,
argued. As I said earlier in this session, he argued that this infringed upon the president's power as commander-in-chief. But it's never been challenged in court. In my view, the court would find it too expansive by taking authority away from the Congress.
The court would or should?
Well, it's a guess as to what it would do, and it depends on which court it is. I don't know that the present court would do it, but before Justice Kavanaugh joined, I think there would have been a 5-4 vote to find this unconstitutional. Just my knowledge of Justice Kennedy, that's all. We have a change in personalities now, and I'm not being critical of Kavanaugh or praiseworthy of Kennedy. It's just hard to say at any given time. The War Powers Resolution is circa 1973, so there have been many Supreme Courts before which it could have been challenged, but never was. Very difficult to get standing to challenge it. But Madison was very, very clear, very clear. If the president can both make war, that is, choose the target, and wage war, that is, be the commander-in-chief of the military, he's not a president, he's a prince. Madison was absolute about why he put the war-making power in Article 1, the Congress, and not in Article 2. And Justice Jackson, the last member of the Supreme Court not to have graduated from a law school, and a former Attorney General of the United States, and one of the most frequently quoted members of the court, referred to this as a loaded gun in the president's desk if Congress doesn't stop presidents from using the military without congressional authorization. But the War Powers Resolution permits that for 90 days and then another 180 days with a simple reporting requirement.
So that sounds to me like a call to action for Congress to step up to the constitutional plate and do their duty.
Congress is gutless. Congress happily looks the other way when it appreciates the target or it doesn't want to get involved politically or it fears defeat. It doesn't want to be responsible for defeat. You know, victory has 1,000 fathers, defeat is an orphan. And that's the attitude that most members of Congress take.
So sometimes, for good or for bad, the hard-nosed constitutional analysis might get left in the rearview mirror.
Well, yes and no. Yes, that happens, but it's never for good. It's always for bad. When power seeps from one branch to the other, the separation of powers is violated. And the separation of powers was written not to uphold Congress's prerogatives, but to prevent one branch of government from having too much power to guarantee personal liberty.
On that note, Judge, thank you for your time and for joining us today. And thank you for watching Talks on Law.